Council, would you please join us on video? Thank you. The Court of Appeals is now in session.
Good morning, Council, and welcome to the Court of Appeals today. Sorry for being a few minutes late. I was attending the And Justice for All breakfast, and traffic was not very great this morning, so I apologize. Council, if you would please, we are here to hear arguments in the matter of Knowlton versus Knowlton. And Council, if you would please enter your appearances for the record.
Julie Nelson for Appellant Brad Knowlton.
Sean Bailey for appellee Shondell Swenson, formerly Shondell Knowlton.
Thank you. I know Ms. Nelson has appeared virtually before in our virtual courtroom. Have you also, Mr. Bailey?
I have argued in the Supreme Court over WebEx.
So you are familiar with the way that this works. I will just give a little bit of a reminder that we will keep our microphones muted if we don't have a question while you are arguing. And if the counsel who is not arguing can turn off their camera and mute their microphone, that is helpful. It helps with the bandwidth and allows us to focus on the arguments that are being made. Do either of you have any questions before we begin?
No, Your Honor.
Awesome. We'll just wait for Judge Orm to, oh, there he is. And I see that Ms. Nelson, you have reserved 5 minutes for rebuttal. Is that consistent with what you have requested?
That's right.
Perfect. Then please begin anytime.
Thank you. May it please the court, Julie Nelson. I'd like to focus my time on the valuation of assent construction and the attorney fees issue. The assent construction issue is important not only for Mr. Knowlton, but for all clients. We have to remember that life doesn't stop just because we're in litigation. And family law cases are especially vulnerable to that. They're supposed to be dividing their lives, but meanwhile, life is not static. Fortunately, family law cases are also especially equipped to handle those variations and those changing conditions. Family law judges have many tools at their disposal to make sure that they can ultimately do their job of doing equity and setting people out on their separate lives on equal footing. They have the ability to maneuver inside of a trial. They have the ability to set aside a stipulation. They have the ability to utterly ignore a stipulation. They have the ability to override normal considerations in favor of equity. And let's not forget that after a decree is entered, a court even then has the ability to change the state of things. A court can, under a petition to modify, a court can make a change if there's been a substantial change in circumstances. Well, here, what happened was the parties had stipulated to have Brad Townsend, no, it's confusing, we've got a lot of Brads, to have Brad Townsend value assent construction, which he did. And he did that in like the summer of 2018, based on numbers from the end of 2017. Trial was supposed to begin in May of 2019, and it was only supposed to last for 3 days, but it took 10 days over the course of 7 months. Evidence continued until October or November of that year. And then there were closing arguments. And in February of 2020, before the trial court had ruled, Assent's sureties sent Assent a demand letter. Assent had been sued, and the sureties didn't back up Assent. Instead, they sent a demand letter. And that significantly was going to change the value of Assent. It made it very, very vulnerable. So within days of that, Brad Knowlton moved the court to allow Townsend to update the valuation. The court didn't do it, and let's keep in mind that, so that was February of 2020. He moves directly. By March of 2020, the surety had moved in and started collecting Assent's receivables. And I think these record sites are helpful to go back and look at. So the original letter is at 11567. Oh, and I see your hands. And the hold funds letters are at 12047. Sorry, go ahead.
Yours was up first.
Can I just ask for a clarification on that point? When Mr. Townsend or Mr. Knowlton asked that to get under the stipulation and for a reevaluation, given that situation, did he provide all the information to Mr. Townsend that was necessary to complete that evaluation? Or was that information either not available or he didn't provide it?
Well, I think we might be talking about two different points. So in February of 2020, when the surety sent a demand letter, we didn't have all that information. And he did it so quickly. Brad Knowlton filed his motion within like 3 days of receiving that letter. So he didn't have all that information. What he was asking was for the court to give him permission to give that information to Townsend so that he could do it. And the court didn't do it. And then when the surety sent its hold funds letters in March, Brad then filed a motion for new trial, bringing this information up. And remember, these events were happening before the trial court ruling was entered. And the trial court declined to do it. It declined to do it on the basis that there had been this stipulation. But that's an abuse of discretion when you've got a stipulation that was okay at the time it was entered into, but now something significant has happened. Something that, if it were after the decree, would count as a substantial change in circumstances. We seem to have this like limbo period where if you have changing circumstances up until trial, you can bring them up. And if you have changing circumstances after the decree, you can bring them up. But they've created this space in between when evidence ends and the trial court ruling is entered. And they seem to suggest that you can't bring up new information at that point, but that's not true. And the problem was that knowing that assent was vulnerable like this, the court nonetheless awarded assent to Brad and gave Shondell pretty much everything else. And not only did he give Shondell pretty much everything else, he required Brad to indemnify Shondell against their personal guarantees that they had both signed against assent, taking away her personal liability for that. Judge Harris.
Yeah, can I ask about this other sort of issue that came up? I guess it was post-trial. You mentioned it on page 8 of your brief, where the shoe was on the other foot, where Shondell was asking for a revaluation or some sort of accommodation to be made in light of apparently some evidence came out at trial where Brad testified he owned more than 50% of the company, and Shondell argued that the 10% lack of control discount should be removed. And your client's position, I know you weren't involved, but your client's position at that time was that no, the stipulation is binding and everybody should be held to the value of the stipulation despite this new information that had come to light at trial. How does that play into this? How do you square your current position now with the position Brad's lawyers took then?
I think that the stipulation originally accounted for the status of things. But what we're talking about here is an actual change of event. We're not even talking about like new information that maybe Shondell could have discovered. We're talking about a change of event. And I would say that it's a substantial change in circumstances. That would be the language that would apply had it happened a few months later. Judge Orm.
I wonder about that in this sense. Assent is, I wonder about that in this sense. Assent is a long-standing construction company. At that point in time, it had been very successful. It's well known that assent has been required in connection with various and sundry projects to post performance bonds. It's well aware these aren't insurance policies, it's a surety bond, and the surety wants protection. And so there are arrangements. If the performance bond is called, we want recourse against the owners. We want recourse against the assets of assent. All very normal. So it seems to me that at the point in time when the other Brad is doing his evaluation, your Brad can point out, now, by the way, we've got some exposure here potentially on performance bonds generally, and more specifically, we got this mess of a thing called the Sugarmont project, and we may well have some exposure there. And if the performance bond is called, the sureties may well be coming after us. Please take that into account in evaluating the business, or even later at the point in time when both sides are just so thrilled, as summarized on page 8 of the red brief, to just have this stipulation in place and be done with it, that your predecessor doesn't say to the court, with one exception, Your Honor, we got this Sugarmont thing hanging out there, or we've got this performance bond exposure. You know what hasn't hit the fan yet, but it might. And if it does, we do need to reserve the right to revisit this. I mean, I have a hard time accepting that this was just absolutely unanticipated event, as you know, like if an asteroid had hit corporate headquarters, sure, who saw that coming? But I'm hard pressed to see how something as routine as a performance bond being called and the surety then wanting recourse was this great mystery that somehow couldn't have been taken into account in more timely fashion. Sorry for the rambling nature of that concern, but it's a substantial one, and I wanted to make sure you had a chance to address it.
Yeah, thank you. First, you're right that this sort of thing happens in the background, and Townsend would have taken that into consideration when he was doing his initial report, which, let's remember, was from the summer of 2018 based on, I think, December 31st, 2017. But the Sugarmont Palava didn't come up until later. Sugarmont didn't sue Ascent until October of 2019. And the surety didn't make their demand until February of 2020. So it's really not accurate that Townsend could have incorporated this particular litigation into his report. And that's exactly what we were asking the court to do, was to allow him to go back and incorporate that information, because things had changed so dramatically. Now, as dramatic as an asteroid, maybe not, but certainly more dramatic than, say, inflation or something like that. I mean, I think that this would count as a substantial change in circumstances post-decree, and therefore it should now.
Let's flip the script a little bit, and let me throw this hypothetical at you. Let's say that in February of 2020, Ascent Construction had unexpectedly gotten the contract to, I don't know, build the new prison, or remodel the Delta Center, or just a giant contract that would substantially increase the value of the company. Would you be taking the same position today as you're taking now? Would Shondell be able to come in at that point and say, hey, we've got some new information that indicates that the company is worth a lot more, despite what we stipulated to 6 months ago? What would your position be then?
I mean, I think arguably, yes. And I think that that's important, because when we focus on what the court's goal is, the court's goal isn't just to hold parties to stipulations and to freeze things from several months ago. The court's goal is to do equity and put people on equal footing. So if all of a sudden in February 2020, Ascent was going to be worth $50 million and Shondell thought she should get a part of that, I don't see how you could argue otherwise in terms of going to the court and asserting that there has been a change and we need a revaluation. I mean, otherwise it would be unfair going the other direction, right? Brad would go away with $50 million and Shondell would go away with all the houses. That's what ended up happening.
I'm pretty sure, though, with all due respect, in Judge Harris's hypothetical, that your first line of defense would be, oh, for heaven's sakes, no, there were risks both ways. Yeah, maybe there's going to be a lucrative contract come along, but maybe our performance bonds get called on some project that's gone south. The parties, by their stipulation, meant to inject some finality into this, come up with a number that they could live with and be done with it. I mean, that's pretty much what they say. We don't want to revisit this again. And there were risks and gains potentially for each side that were given up in the process. That seems to me perfectly defensible.
Well, and, I mean, that would be, I suppose, the other argument going to the court. But the point is that a court always has the ability to undo a stipulation if it thinks it's inequitable. And so if the court looks at the facts as they are on the ground before it's entering its ruling and is like, you're right, this isn't going to be equitable, then the court has the ability, and I think should, under the case law, revisit it. Now, if the court were to look at it and say, it's equitable because this, and this, then I wouldn't be here arguing this. But that's not what happened. What happened here was they just were entrenched in this stipulation. And our position is, but you can get around a stipulation. And we filed a motion for new trial on the basis that we had this newly discovered evidence. So on the basis of both of those things, I think it's an abuse of discretion. Well, I will turn my screen off now.
Thank you, Ms. Knowlton. Haley?
Good morning. May it please the court. Brad's challenge to the stipulation to the value of assent fails. It is clear that the Sugarmont lawsuit was served on Brad on October 18, 2019. The Sugarmont lawsuit alleged damages against assent of $38 million and growing. The record reference for that complaint is 11608. The record reference for the certificate of service showing Brad himself was served with that is 11663. If you look at that complaint, it is clear that that dispute did not arise suddenly. It outlines a long series of events leading up to the date that complaint was filed in October 2019. There were demands made by Sugarmont against assent preceding the trial of this matter even starting. Once Brad had that complaint served on him, he waited over 4 months to bring the issue to the court's attention. Brad presented evidence in this case on October 30th, 31st, and November 1st, but he didn't mention the Sugarmont dispute. He didn't make any claim that the value of assent had been reduced, and he didn't seek relief from the stipulation. Again, in December 2019, Brad filed his written closing arguments. Brad didn't seek relief from the stipulation then either. On the contrary, he expressly reaffirmed to the court that he had accepted this stipulation both to the value of assent and to the allocation of assent to him. So Brad's request for relief was not preserved for appeal. It was untimely. Furthermore, turning to the merits of this request for relief, Brad failed to demonstrate the stipulation was inequitable in any way. Brad didn't present any evidence that the value of assent had actually changed. At best, he presented the existence of a lawsuit, and then he speculated that that would someday change the value of this asset. However, the claim that an allegation or a lawsuit is the same thing as a change in value is simply not the case. That claim conflicts with Assent's own treatment of this lawsuit. Assent filed an answer denying this debt. Assent filed counterclaims against Sugarmont claiming substantial damages. It's certainly possible that Assent will prevail in that lawsuit and come out even better than it was before the lawsuit.
Does the record before us contain any information about how that lawsuit is proceeding or has proceeded? And I think you just mentioned in your answer just a second ago that it is still proceeding. So I guess the answer I'm inferring is no. If that lawsuit's still ongoing, anything about it wouldn't be in our record. But I just want to make sure that I understand the landscape there.
Sure. So, Your Honor, in the record, we have the complaint at 11608, the docket in that case, which starts at 11650, and the certificate of service on Brad at 11663. The docket does show what happened between the filing of the complaint in October 2019 and the briefing on this motion starting in February 2020. And so it does show, for example, some pretty significant litigation in that time period over preliminary injunction. It does show Assent filed an answer and counterclaims. It certainly indicates Assent is fighting this vigorously and pursuing counterclaims against Sugarmont, and that Assent may ultimately prevail. So there's no showing of inequity on that front. Furthermore, there's no showing of inequity in the sense that this court looks at whether the agreement was fairly negotiated. And clearly, Brad founded this company in the roughly 20 years between the year 2000 when he founded it and the date of this stipulation. Brad personally managed this company. Of anyone in the world, Brad was in the best position to evaluate whether this stipulation was fair to him. Furthermore, when he entered into it, Brad had the advice of counsel and business valuation experts. So clearly, the process was abundantly fair to Brad. Now, Beyond that issue, Your Honors, Brad's unclean hands prevent him from resorting to equity at this point to back out of this agreement. There was a substantial dispute between the parties in the months preceding the trial, continuing on to the first day of trial, about whether this valuation would be updated. The court ordered Brad to produce information concerning assent, post-2017 information concerning assent. So it's 2019, and Brad claims post-2017 information does not exist. Well, the district court understood the fine distinction that Brad was trying to draw there. He was claiming that if I haven't deemed a record finalized, then it doesn't exist. And so the court said, you've got to produce these materials, and if you claim that they don't exist, then you have to produce a declaration explaining what doesn't exist and why it doesn't exist. Well, Brad defied that order. He refused to produce these records to prevent the valuation from being updated. So there we were on the first day of trial. Assent's in-house accountant is on the stand testifying that these post-2017 records do exist, and Brad hasn't turned them over. That put the court and the petitioner in a very difficult situation. And ultimately, we had to come up with a solution to that, whether we have a fight right then and there in trial, forcing these records to be produced and the valuation to be updated at trial, or whether we form a stipulation to agree that we're going to use this existing unupdated valuation for all purposes at trial. And ultimately, that's what the parties did. Yes, Judge Orm.
It strikes me that that isn't so much a matter of unclean hands as it is yet further consideration that flowed to Brad by this stipulation being implemented. I mean, the alternative was, gosh, I'm potentially in contempt of court here. I didn't turn this stuff over. My accountant says some of it's available. Well, the last thing I want is a continuation of this hearing, maybe thinking to himself, I'm thinking the value may go up a little bit, and a nice way around it for everybody. Let's just stipulate to the old figure. Your client loses the ability to argue, let's have a 10% increase. Brad, in the short term, is thinking, yay, we don't have to get into all that with the new documents, etc. I mean, it strikes me as yet more solid consideration for the stipulation rather than unclean hands, at least in the way that I tend to think of that doctrine.
Your Honor, I think that is a fair characterization. I guess I would respond, I think it can be both, because it's clear what Brad had to gain in that moment and what he did gain by entering into this stipulation. Furthermore, what I'm saying is it's not fair at this point for Brad to invoke equity to back out of this agreement when his conduct was frankly intentionally wrongful to prevent this valuation from being updated back on the first day of trial. So it wouldn't be fair when he's behaved improperly to prevent this valuation from being updated to now use equity to back out of it. This court has made it clear, if the agreement was fairly negotiated, and if there's no actual showing, like here, there's no actual showing the value of assent is actually changed, then equity is not an escape hatch where parties can back out of valid and binding agreements that they've entered into. I think another important point, Your Honors, is that this court also has addressed a very similar situation in the Robinson case, where one party wanted to back out of a stipulation, claiming that when I entered into this stipulation, I made assumptions about future events that didn't turn out to be true, that didn't turn out to work out in my favor. And this court said, well, mutual mistake may be a basis to back out of a stipulation if there's a mistake as to a fact existing at the time of contract formation. However, you can't undo valid and binding stipulations because you get down the road 6 months or a year or 2 years, and you say, "Wow, this asset isn't worth what I hoped it would be. I want to redo. I want to negotiate a better deal." Um, there has to be some sense of finality in these cases. And one of the best ways for parties in divorces in the state of Utah to obtain finality is to enter into stipulations where they can eliminate the risk of having issues like this fully adjudicated at trial, and instead come to some agreement where they may have to compromise and give something up, but they also get something of value in return. And Utah courts should honor those stipulations and enforce them unless there's some extreme reason why it shouldn't be. And frankly, there's no issue here that would justify invalidating this stipulation. There's some other issues, Your Honors. I'd be happy to address more on that issue. There's some other things I can address as well that I noticed in the reply that I felt like needed correcting. One, the assertion has been made that this lawsuit filed by Sugarmont is a debt and that it actually changed the value of assent. That is clearly not accurate, as we've discussed. It's an unresolved claim, and it may, and assent very well may prevail in that lawsuit. Yes, Your Honor.
Mr. Bailey, I should have asked this before when you gave us a little break moments ago, and I was a little slow on the update. We recently had filed this satisfaction of judgment. A judgment was entered against Mr. Knowlton in favor of your client, and we now have a satisfaction of judgment filed. In simple terms, is that just an FYI, or does that end up resolving some part of the issues before us? Or would you be kind enough to explain, maybe I should just put it this way, would you be kind enough to explain the effect of that judgment? It's the fact that it's been satisfied speaks for itself, but what was that judgment all about? I guess that's
Sure.
what I'm asking.
Sure. Thank you, Your Honor. So one of the issues was unauthorized payments from the home equity line of credit that encumbered the marital residence. And Brad challenged the district court's treatment of that issue in the trial ruling and in the decree. Subsequent to the decree and subsequent to this appeal being filed, there were enforcement proceedings concerning that issue and other issues. Those enforcement proceedings, for the most part, were resolved in Shondell's favor. And so a substantial portion of that judgment entered against Brad was for those unauthorized home equity line of credit payments. Brad did not appeal that judgment. After even more enforcement proceedings, Brad ultimately paid that judgment in full, and Shondell then filed the satisfaction. And so our position is that that issue is moot because judgment was entered, Brad didn't appeal, Brad paid the judgment, and a satisfaction has been filed.
And nothing in the record to indicate that he was paying under protest, reserving his rights to fuss.
No, Your Honor. There is nothing like that, either in the record or when these payments were made after the record was finalized, that there was no statement that the payments were made in protest or anything like that.
Thank you.
Yeah, I have a question about something I read in the reply brief with regard to this reconciliation argument. In your response brief, in the red brief, it looked like you understood the argument being made in blue as limited to the cabin expense issue. And it looks like Ms. Nelson coming back in gray indicates that she thinks there's two components to this argument, one having to do with income and reconciling the $15,000 a month that both were supposed to be entitled to. And then that's separate in her mind, I think, from this issue with regard to the cabin. And she chides you a little bit by saying Shondell makes no response to Brad's argument about the income. And that struck me as interesting, and I thought I'd give you a chance to respond to her contention that you made no response to that, and maybe explain your understanding of those issues and whatever you'd like to say in response to that argument there.
Thank you, Your Honor. I appreciate that. So the cabin is a specific example of a bigger issue. The temporary order in this case, of course, formed at the outset of the case, says something to the effect that Brad would make monthly payments of $15,000 to Shondell, and that Brad would also receive an equivalent amount. That temporary order did not accurately describe what happened in the ensuing 30 months between the date that this was filed and the case was submitted to the court after closing arguments. What actually happened is Brad received over $3 million in marital income, over $100,000 a month, and there was never any evidence or other effort on Brad's part, or frankly anybody, to distinguish between the $100,000 of marital income that Brad received and some lesser amount that was designated as money Brad received for his personal, day-to-day expenses. So at trial, Shondell asked the court to award her an equitable share of that $3 million plus in marital income that Brad received during the pendency of the divorce. The trial court denied that request, and the basis for that in part was Brad received those funds and used a part of them to maintain marital assets. And there was no showing by any party that Brad used any separate or personal funds to maintain marital assets. And so the cabin is one example of that, where Brad is now demanding reimbursement, but there's no showing that Brad spent separate or personal funds to maintain the marital cabin. On the contrary, it's clear that those were marital funds, and therefore Brad's not entitled to reimbursement for that. And the same goes generally. The demand for reconciliation, it focuses in on the language of the temporary order, but it doesn't take into account what actually happened, and that is Brad controlled virtually all of the marital assets. He received virtually all of the marital income, and he had that at his broad disposal and used that both for himself and to maintain the marital assets. For him to demand reimbursement, or as he calls it, reconciliation at this point, he would have had to make a showing that he actually spent personal or separate funds maintaining the marital estate, which he's never done.
Or he'd have to show that there wasn't, he paid Shondell $15,000 a month out of whatever assets there were, but then he'd have to show that there weren't $15,000 a month left over for him to enjoy. I think that's sort of the implication of the argument, as I understand it. And from what you're saying is, well, no, there was $100,000 a month that he got to keep, and if he had asked for a reconciliation of this nature at trial, it would have come out vastly in his favor. And as I think I'm hearing you say, to the contrary, it was Shondell at trial who asked for that sort of reconciliation, and the trial court denied it. Am I tracking your argument?
Exactly right. To be fair, the amount Brad received was over $100,000 a month, less the $15,000 that Shondell got. And if this reconciliation had actually been done, certainly a payment would have been coming to Shondell, not back to Brad. So if there's nothing more, Your Honors, I appreciate your attention to this case, and I'll leave it at that.
Thank you, Mr. Bailey.
Thank you.
Appreciate your argument. Ms. Nelson?
Thank you. I might start with this $100,000 a month argument, which I would note they haven't appealed, and I'm not actually familiar with that number. The court found exactly that the court found that Shondell's claims about reconciliation in her direction were flawed. The court asked Brad to trace everything that he had spent, which he did at great expense. And after he did that, the trial court decided that everything that Brad had spent was appropriate. That's at 12,476, but also decided that, he'd spent money on attorney fees. And the attorney fees is problematic. That's related to that issue that Brad had paid this attorney fees, and the court then asked Brad to reconcile that with her. But on the flip side, we never saw what Shondell spent. We have no idea what Shondell's resources were. We know she had $15,000 a month. We don't know what other assets she had. We don't know what income she had. She never disclosed any of it. And when we tried to ask about it in questioning, the court cut it off as irrelevant, saying that the income and expenses didn't matter because it wasn't an alimony case, but used it as a dissipation claim. So first off, on the attorney fees issue, we have a problem there, and this court should not permit a dissipation claim when you've got absolutely nothing on the other side to show what had happened. And we do have the reconciliation argument because that temporary order was clear throughout that everything needed to be reconciled. This was just a Band-Aid to help people get through. It wasn't dividing the estate as of the date of separation. It was just a Band-Aid we were going to go through and we were going to reconcile. And we now have clear case law that temporary orders in alimony and child support can be reconciled. This temporary order was asking for that, and then the court didn't do it, but it should have. Moving back to the assent issue, I think that Shondell's point shows that Shondell didn't think the stipulation was all that binding either. She twice asked to be freed from the stipulation, and now she wants to blame it on Brad, but the court ordered Brad to disclose information or provide an affidavit why he couldn't do it, and he did the latter. He provided that affidavit as to why he couldn't do it. That was at 6597. And at that point, Shondell decided to stop pursuing it. So it's really not an accurate telling of the facts to then say that it was Brad who hid behind that. But what we see from it is that Shondell agrees that stipulations don't have to be binding. And we have decades of case law telling us that stipulations don't have to be binding. Now, I want to point the court to page 12047 because that's a declaration of Brad where he explains what's happening with the surety. This is in March of 2020. It wasn't just that the surety started demanding, but the surety then started collecting. They took over all of Ascent's receivables so that Ascent hasn't received any receivables since then, and it wasn't receiving receivables at the time. Well, that was not anticipated. As Mr. Bailey pointed out, the litigation had been going on and there was some hope of resolution, some hope of settling it. You know, a lawsuit by itself doesn't change the value. But when a surety takes over your receivables, that absolutely changes the value. And that was where Brad came in and asked the court to look at it. Now, we didn't have information at that moment of what Ascent's value was going to be. That's why we needed Townsend to do it. And Townsend said he would, but didn't. And stipulations, even in property settlements, the case law language says they're not sacrosanct, that parties can stipulate to property settlements. They can be set aside. They can be set aside before ruling, and they can be set aside after ruling if there's been a change. Even a property distribution is subject to a substantial change in circumstances. That's what we have here. We know that the surety's actions were causing new problems that had not been anticipated, had not been accounted for. And for that reason, we think that the trial court abused its discretion when it gave Brad what turned out to be a liability, gave Shondell everything else, including Brad's house, and also required Brad to indemnify Shondell against something that she had personally guaranteed, right? They had both personally guaranteed it decades ago. And then the court took that away from Shondell. So she's not even liable on the claims anymore, and moved it and assigned Brad to indemnify her. For that reason, we would ask this court to reverse.
Thank you, counsel. And Mr. Bailey, if I could ask you to, oh, there you are. Thank you, counsel, both of you, for your arguments today. Very helpful. We appreciate the time that you spent and appreciate your effort as well. We will take this matter under advisement and render a written decision as soon as we are able. And with that, we will be in recess until 10 o'clock. Thank you.
Thank you.